Welcome to the podcast. I'm your host, AJ Richmond, criminal defense attorney and Title IX attorney. Tonight's podcast is going to be about comparing the Title IX process to the criminal justice system. So, it's very likely if you're listening to this, you probably have just received what's called a notice of allegation or a notice of accusations from a university or a public or private high school or middle school. That's what starts the Title IX complaint. And in a criminal case, this would be similar to having warrants or having an indictment or having an accusation brought against you. In the Title IX in the school process, which is what we'll be focusing on, that is brought by the university, also known by the DTICs or the Department of Title IX. And what happens is a person, usually the victim of an alleged crime, brings this case to a teacher, to a staff member, or to the Title IX office, and they say, hey, so-and-so touched me, so-and-so harassed me sexually, so-and-so is discriminating against me for being whatever, either gender-based or sexually based. And the school then has a duty to then start this process against you. And again, that's called the notice of accusation. And what happens is the school's objective is to determine whether or not those allegations of either sexual misconduct or sexual harassment make the victim's life in the university basically unsafe. Okay, so did you do something that's so bad in nature where this student can't continue going to the university without feeling safe? And once the Title IX process starts, and once you get a notice of allegation, what's called investigations starts. They call it the investigative process starts. The Title IX case is usually given to Title IX, quote, investigators. In my experience, those investigators are usually attorneys or simply people that work at the university. I've never seen Title IX investigators that were police officers or that really had any law enforcement experience. Just the opposite is true for criminal justice cases. If you get arrested, 99.9% of the time, you're being investigated by the local law enforcement agency, the local Department of Law agency or Department of Justice agency. So on one hand, on the Title IX hand, very low funded resources. You're not going to find really any fingerprint evidence, really any cell phone evidence. You're not having investigators that look for that. They're just simply gathering statements from people that give them statements. Where again, on the law enforcement side, on the criminal side, they are looking for evidence. They're going out and finding evidence, forensic evidence that will either help you or hurt you. Now, one of the huge differences in a Title IX process is what's called the standard of proof. So in the Title IX process, you're dealing with what's called a preponderance of evidence standard. And if you think about a percentage, 51% is what the school needs to prove that, yeah, you sexually harassed this person, or yeah, you sexually assaulted this person. 51%. So if you have two people, you said no, and the victim said you did, that's 50%. But if you said you didn't do it and the victim said you did do it, and somehow there's a picture of you, let's say at the victim's apartment, that might get over the 51%. Or if a witness says, well, I think he did it. Whereas in the criminal justice system, that's what's called beyond a reasonable doubt, and you're looking at 99.9% that you did it. So it's very easy to be charged, and it's very easy to be found responsible in school for a Title IX complaint because the standard of proof is so low. And a lot of the phone calls I get are, well, I can handle this myself because I didn't do it. Or I can handle this myself because I know that there's not any other evidence other than what she's saying. And I'm here to tell you that that's all the university really needs without a fight, is to say, you know what, we believe the victim and not you. The next stage after that is going to be what's called the resolution. So usually in a Title IX process, the universities like to resolve the entire case from start to finish in 60 days, maybe 90 days. And what happens is they rush through it. And at the end of the Title IX at the end of the Title IX investigative phase, you're going to have the whole report, like you would in a police report at the end. But in the Title IX, at that point, that is when you can figure out, do I want to provide evidence or do I want to have a hearing? And what a hearing is called in the Title IX process is a formal hearing. And with a formal hearing, what that means is you're entitled to have a hearing pursuant to the standard policies of that university, which usually includes some type of academic advisor, some type of faculty member, potentially a student, and the Title IX coordinator. Those are going to be your hearing panel. That's going to be the equivalent of a juror or a jury in a criminal case. So in a criminal case in Georgia, if it's a misdemeanor, you get 6 jurors. If it's a felony, you get 12. In all Title IX cases, you may only get 2 or 3 people that are going to listen to you. And those are usually members of the university that's charging you. They're usually teachers. Now you have the option to challenge them for what's called bias, or to say, look, they shouldn't be, qualified to serve as hearing panelists. A lot of times we come up with ideas on how to do that. Some of them are, we've had plenty where the hearing panelist, maybe one of them was part of the Me Too movement. She or he posted things on the internet, which we found, which said, hey, this probably isn't the most fair person. So we're able to exclude or eliminate those people from being your hearing panelists. But that's going to be sort of what you get in a hearing. The rules of evidence. In criminal cases, we have rules of evidence that lawyers go to law school, lawyers get continuing legal education. They change almost all the time. Case law, case precedent. But in Title IX hearings, at least during this president's view for the Department of Education, the rules of evidence may be almost none. Meaning the standard phrase of, well, that's hearsay, or somebody said it but they're not here to testify, it may not matter. The evidence may come in. Text messages, the complainant may have a text message with a whole nother person that doesn't come and testify in your hearing. That may come into evidence. Stuff that you have may not come into evidence. We just had a hearing recently where we had maybe 50 text messages that we had that the hearing officer ruled was not admissible. We fought that in an appeal and we won. But they make the rules. There's no judge. And most importantly, there's no way to get it in front of a judge during the hearing. You have to wait till all that's over through what's called an appeal. But just going back to the hearings, after a hearing, if the panel decides that you did it, or that you are responsible for the sexual harassment or the touching or whatever with the student, you have what's called sanctions. So in a criminal case, you have punishment, prison, probation. In a Title IX case, you have sanctions, and those are just as deadly. For example, if you are a student, a 9th a freshman, a sophomore, a junior, even a senior. One of the sanctions could be, we're going to suspend you for a semester. We're going to suspend you for a year. We're going to expel you. We're not going to let you graduate. Those are what's called sanctions. Those are very, very important. Even if they don't sanction you that hard or harshly, and they make you write essays or they make you apologize, you now have to check that box for the future if you're applying to school, medical school, law school, becoming a teacher. And the question's going to say, have you ever had any disciplinary action taken against you in school? Well, if you were found at fault and you were given a sanction, you'll now have to check the box, yes. And we don't ever want that to happen. The final thing you have in a hearing in a Title IX case is what's called an appeal. And that's when we can decide if there was evidence that should have been entered into the hearing that wasn't, that there was newly discovered evidence, like the complainant right after the hearing wrote something on Facebook or Instagram that was different than what she said or he said. We can have an appeal and have the university redo the hearing. Maybe the hearing officer you found out actually was biased and actually was part of a group or an association or said something that could hurt you in a fairness standard. We can now say, judge, or to the school, hey, we shouldn't have had that hearing. And in a criminal case, of course, we get to use judges and court of appeals and Supreme Courts. You don't have any of that in Title IX. Now, finally, you as a Title IX respondent have the right to have what's called an advisor, and that would be me. Your advisor could be an attorney, it could be a teacher, it could be your family member, it could be a friend, but you have the right to have an advisor. Now, most of the time, the advisors can ask the questions, can do all of the cross-examination during the hearing. But throughout the process, meaning when you're emailing your Title IX coordinator, when you're responding to questions, when you're asking questions of the advisor outside the hearing, we're not allowed to do that. You have to do that. We'll tell you what to say, but you have to do that. But having an advisor is so critical. And let me just rant a little here. This Title IX process is going to be the most unfair process you'll ever go through. Whether or not you're a faculty member or a teacher or professor going through this, we represent all three of those individuals. But it is unlike anything else you've ever been through. You would think that the school would help you. They don't. You would think that the laws are in your favor. They're not. You would think that there has to be some fairness to all of this since it's all through the Congress and congressional statutes and all this. There's not. It's not fair. And you would think that the people doing this would actually feel bad for you based on the lack of evidence that a hearing panel hears, and they don't. So when we win these cases, and we win a lot, it is, I feel, really a true sense of helping someone, because if the allegation actually is really, really fake, or somebody did it because they wanted a better grade, or you somehow embarrassed a student with a question or an answer that you gave, whatever the case may be, if we're able to keep your job, if you're a teacher or you're a professor or you're a lecturer, or we're able to keep you in school, or we are able to keep your son or your daughter, if you're a parent, in school, right? That to us is a massive victory, because everything is against you in Title IX, and the only thing you have in your favor is your advisor and his help or her help throughout the process. So let us know if you have any Title IX issues. We do work all around Georgia. We've done work at Emory, Georgia State. We've done work at Piedmont. We do a lot of work at UNG, University of North Georgia, We've done work at KSU, West Georgia, Valdosta State, everywhere, down in Macon. I mean, you name it, we've been there. And if we can't help you, or you're in a place somewhere else other than Georgia and you want a local lawyer, just let us know and we will help you out.